everyone. Welcome to Redbust US channel. Yesterday, USCIS updated a policy on discretion and how it applies to EADs and other things. So in this video, we will cover all these aspects like what is discretion, how do the USCIS office actually looks at it, what is the process, the impact for H4s and H1s and other aspects, right? So if you haven't subscribed, do subscribe our channel for regular updates. So firstly, right, this is the news that was announced yesterday. And in fact, it has created a lot of panic among all the H4 EAD holders and other EAD holders that are out there, right? So the reason for this is, as you can see, President issued a proclamation that addresses or the executive order, for reviewing the employment benefits. And this policy update is coming from that aspect, yeah. Now, discretion is actually not new, so this is used by USCIS for various adjudicative reasons, So just to look at the basics, right? From immigration law standpoint, uh, there are two kinds of discretions. One is a prosecutorial, which is basically used for enforcement, right? And the second one is adjudicative, which is to decide or judge. So in USCIS context, they use this adjudicative discretion. And again, this is, as I said, this is not new and used by other forms. Now, what it gives is, the discretionary, the discretion concept or the adjudicative discretion gives the USCIS officer, freedom to decide what to do, in an application context, by looking at it from a holistic perspective. So essentially, it's giving them to make a choice looking at the various aspects that may or may not be measured using document, may or may not be measured, with other aspects. Yeah. And how is it actually used by officers is they would look at all the factors that are either positive or negative regarding to a case, and then they use their judgment. Basically, discretion is the personal judgment, right, based on the totality of the application. And then if the positive factors outweigh the negative factors, then they approve the petition. But if the negative factors are more than the positive factors, then they deny the petition. So it looks a pretty simplistic thing, but it is subjective. It's as it says, discretion based on personal judgment, and can be sometimes not very realistic, right? Now, looking at it, what are the forms that actually are impacted with this, right? Or currently, with this policy changes, or right? As you can see on the screen, we have actually tabulated in a nice form, right? Where it applies and where it doesn't apply. So if you look at H1B, L1, other holders use I-129 form, it does not apply, right? And only few exceptions. Those are related to K1 applications, I would say, right? And if you look at H4, F1, extensions that use I-539 form, right, using change of status or extension of status, then it impacts that. There is a discretionary review there. And all the EAD things that are tied to H4, F1 OPT, STEM OPT, adjustment of status, all of these that use I-765 form are applicable. Of course, there are some exceptions here, right? And the other one is employment-based green card petitions, right, which are basically I-140 form that use, it's applicable in that context as well, or investor visas, or anything that's related to I-485 forms, adjustment of status, and other aspects like K1 visa, humanitarian parole, all of these it applies. And of course, it doesn't apply to naturalization and citizenship certificate. Yeah. So this is a quick summary of the forms that it applies. Now, if you look at the context of the policy alert, it is actually tied to employment-based, applications, and Trump wanted to actually look at them in closely, right? So they've actually added some clauses where the EAD applications that have discretionary review, and all of them that fall under these are these, right? So F1 visa, either STEM OPT, or economic hardship, right? If you're an F1 student and you're like having economic hardship, you could get that, or M1 visa holders. H4 EAD, very, very important. This is one of the big items, many people are worried. And DACA holders, adjustment status cases, and all of the dependent visa holders for A1, all of these, right? Which all of these get EAD. If you look closely, there is no L2 here, yeah. So it's very, very important for you to know that. And also certain asylum cases, domestic servants, TPS, all of these are various EAD applications that will have discretionary review going forward. Now, how will USCIS use this discretionary review, or how do they adjudicate, this process, right? So this is a very simplistic process that's very straightforward, I would say. So the step one is basically they need to get all the facts in the case. It could be immigration history, criminal history, eligibility, all of these things. You'll get all of the documents and facts. And second one, what the first step is, they want to look at the eligibility. If the eligibilities are met, then they can actually, then they'll go to the next step. If not, they can technically deny a petition. In most of the cases, they issue an RFE, but they have the right to actually deny a petition. So this is something to consider. So when you send an application, you need to make sure it is actually complete. Yeah. Again, if all are met, then they go to the second step, which is or the last step, which is the discretionary analysis. Now, what they do in that is discretionary thing is they actually look at all the factors. Again, there is no set of discretionary factors defined. It's not like a list of 100 things that that they look at. It's very much subjective, right? So they look at all aspects. So depending on the kind of application that you're doing with USCIS, they will look at, okay, does this person has good conduct, character, immigration status, what are the ties to US, does he have any criminal activity? So it's very, very generic, right? So these are they look at it from a holistic level. But nevertheless, USCIS has given a set of things that you would typically look at, right? So this is the fundamental thing is the eligibility, right? And if they have not done any fraudulent documents related to eligibility, have they paid taxes, have they been compliant with and maintaining status, do they have any criminal history, or have they been a problem in the for national security or any public safety issues, have they done any fraud? And if it's an immigration petition based to family based, do they have the proper family ties? Did they work in US armed forces? Were they part of owning a business, or real estate, or they own real estate to show ties? Were they a good citizen in the community by doing community service? And if they're doing applying for marriage-based green card, was there any false intent just to get a green card, right, when they marry? So all these are the many various things, right? Again, as I said, there is no list. So these are some of the things that USCIS has given in the documentation that they could look at. Now, once they look at all of these factors, that's when they look at them as if they're a positive or a negative factor. So they'll weigh them as a positive or negative factor and then come up with a decision. And the very important factor, they can't give a numbering, right? Okay, this is a positive factor, I'm going to give 10 points. This is a negative factor, I'll give -5. You can't do that. That's what USCIS guidelines tell. So they cannot give any points, but they have to look at it from a holistic case of and look at these factors. So they should see the factors, how they're related and how they impact the overall application. And as I said, if the positive factors outweigh, then they give approval. And if the negative factors outweigh, then they would deny the same. And again, if there is no negative factors, still, the requirements, the fulfillment could be treated as a positive factor. So don't need to worry. If there is no negative factor, then you're good. That's what it means, right? And one important guidance is they cannot deny just saying, it's our discretion, right? They need to give proper explanation in the denial notice. What are the factors they considered and why they denied? So it's very, very important. Now, the second aspect, right? How does this impact H1B and other visa holders? We looked at it on a high level, but here is how it impacts I-129 form. So there is no direct impact for non-immigrant work visa holders on H1B or L1 visa. So this is a screenshot from the actual policy manual. As you can see, petition to classify an alien non-immigrant worker. The discretion is not involved, with some exceptions. Those exceptions are usually tied to K1 and which use of I-129F kind of forms, right? So this is H1 and L1. So don't worry, there is no impact on H1Bs and L1s in general. The second one is EAD, right? So this has been the biggest contention point or confusion point, right? So again, the policy came because of the executive order. So what they could look at is did the applicant, because EAD applicants, they were given just like that when you apply, they would look at some basics and rubber stamp it, right? But now with this discretionary review, they could look at the individual history. Did they maintain the proper status in F1? Or did they pay taxes properly? When they did a change of status, were there any violations? Or were they enrolled in a CPT program? And if they were enrolled, were they in some kind of day one CPT? And was it legal in first place? Did they violate status? And was there any fraud that they did? In the past, when they were on H4 EAD in the previous ones, right? So these are some of the things they could look at, related to the conduct. Again, this is not something that is comprehensive, but these are some things that you should be prepared when you are actually submitting EAD applications for H4 EAD or F1 OPT, STEM OPT. And the big issue is, if they deny this, it's not subject to administrative appeal. Essentially, there is an appeals process that you could appeal the decision, but you cannot, right? As you can see on the screen, this is the regulation. As in the last one that is highlighted, you see the denial of employment authorization is not subject to an administrative appeal. So there is no appeals process, if they deny it based on discretion. Of course, it is their they need to give proper explanation, but again, you cannot really go for administrative appeals. So this is on a high level. So again, there is no L2 here. It's very important because it does not fall under a certain category. So that's why. And another FAQs, right, on the policy memo discretion, right? So if you look at the common FAQs, this is effective from July 15th, which is basically yesterday. So, so technically it's effective. And I mean, do you expect to see more H4E denials and H4? It's too early to say, but again, they cannot just give denials without proper explanation. They need to give, analysis for this and everything, right? So if you're in good status, have not been involved any issues, you pay taxes, you're in proper status, you should be fine. And will this apply to pending EADs and other applications? Again, they have not given any exceptions that this won't apply to pending applications. So basically, then it means that it will apply from July 15th itself, which is from yesterday. So this will apply to all of that. So those are the FAQs, folks. Hope this was helpful. Thank you again for watching. Do subscribe for updates, and we will keep you posted with new updates.